Today, we go inside the Michigan DUI playbook, and discuss how to pick a jury for a drunk driving trial. Attorney Jonathan Paul discusses the best approach to winning your case. Jury selection is important for 4 reasons. It's the only time that the attorneys can interact with the jury. It's a chance to create a collective mindset of people from different background and walks of life. Leaders emerge within that group, which can impact other jury members. It's a time to earn supporters who are willing to travel down your path, which you present your theory of the case. The prosecutor who will have their own theory on the case. Finally, it's a chance to educate the jury on a number of issues. The goal of the defense attorney during jury selection is to educate the jury on the burden of proof, presumption of innocence, and the defendant's theory of the case. Can be useful to establish a collective mindset favorable to the defendant, establish a bond with the jury, negate drunk driving publicity, and prepare the jury for the trial. Here are some goals in creating a collective mindset of the jury. If the jury collectively follows these bullet points, a defendant is in a good position to win their case. Here are the 3 main obstacles that must be overcome during jury selection. A defense lawyer must address all 3 issues and change the perception of the jury. All question sets should be structured either to make a point with or to elicit information from the juror. It is also possible to suggest the defense theory through questioning. If the jury is unwilling or unable to require that the prosecutor prove each and every element beyond a reasonable doubt, the jury instruction allowing them to infer an unproven will always result in a conviction. The importance of educating the jury on the burden of proof and the presumption of innocence is your only chance. Issues such as alcohol absorption and passage of time must be introduced during jury selection. The key is overcome the inference that the BAC reading of the data master or blood draw is the same as the defendant's level when driving the car. If you overcome the inference, then you've created reasonable doubt, and you should win every time if a jury is properly educated and follows the law. The prosecutor will attempt to shift the burden during trial, and put the weight on the defendant to fight for their innocence. This must be addressed during jury selection. By law, the jury can believe that the defendant committed the crime, but if the prosecutor has not proved it beyond a reasonable doubt, the defendant should be found not guilty. The jury must also understand that the defendant is entitled to a verdict of not guilty if the prosecutor fails to carry the burden of proof. DUI cases will be won or lost based on the inference of the BAC level, because it is very likely to be over the legal limit. Without the inference, a prosecutor cannot win. Nobody likes a drunk driver, and nobody is willing to give that person the benefit of the doubt if they are sitting in the defendant chair at trial. They had to have done something. Jurors need to be reminded that publicity can affect decision-making in all kinds of ways. They know what advertising is all about, and they will all acknowledge it could have on the ability to find the defendant not guilty despite the charges. If anything, this predisposed mindset can be used in favor of the defendant, almost in the same way that a parent might play their kid less if coaching a team even if they are a better player, simply because they don't want to appear to be playing favorites to their child. A DUI defense attorney in Michigan has 2 paths to keep potential jurors off a jury. You get 3 peremptory challenges for a misdemeanor and unlimited challenges for cause. A peremptory challenge means that the defense attorney can excuse 3 prospective jurors for any reason at all. Challenges for cause are extensive, but most commonly relate to bias against the party, certain state of mind not favorable to a fair and impartial jury, relationship to party, sat on previous similar trial, financial or personal interest.